Upon completion of this entire class, the student will be able to 1. Locate important addenda and other contracts used in the real estate business. 2. Explain the statute of frauds. 3. Describe the difference between the lead-based paint disclosure form and the lead-based paint contingency addendum and under which circumstances you should use each form. And 4. Indicate where state-approved forms can be found. Real estate agents do not become attorneys when they get their real estate licenses and are not authorized to draft contracts, even real estate contracts. A Utah real estate licensee is permitted to fill in the blanks on state-approved forms. These are forms which have been approved by the Real Estate Commission for use by real estate licensees to assist their clients in Utah real estate transactions. If there is a form currently approved by the Utah Real Estate Commission, the licensee must use the state-approved form. For purchasing or selling real property, the state-approved form is the REPC, pronounced REPC. There is not an option to use other forms from other states or from any other place a licensee may find a form. Nor can a real estate licensee create their own forms. Doing so would subject the licensee to fines, more education, and/or revocation of their license. If there is not a form approved by the Real Estate Commission for a particular purpose, such as listing a property, the licensee may fill in the blanks on forms designed by the brokers or a client's attorney, real estate membership organizations, or even a forms supply company. In some cases, forms which have been designed by real estate membership organizations, such as the Utah Association of Realtors, or by companies, are for the exclusive use of their members or agents. Be careful not to use a form from an organization to which you are not a member or otherwise associated. One thing a licensee must always remember is that the statute of frauds states that all agreements in a real estate transaction must be in writing to be enforceable. Real estate transactions are too important to rely on a handshake and the fact that the buyer and seller seem like such nice people who have been getting along and cooperating throughout the transaction. Even the most reasonable people can become emotional in the process of a real estate transaction. People who always seemed stable to you in the past may suddenly become very unreasonable. If a buyer and seller have verbally agreed to something, such as the inclusion of a lawnmower in the sale, it is the agent's responsibility to get this agreement in writing, typically with the use of a blank addendum signed by both buyer and seller. If the agent doesn't get the agreement in writing and the seller later takes the lawnmower, the buyer won't be very pleased to find out the seller's promise to leave the lawnmower is not enforceable because their agent didn't get it in writing. The buyer's agent will have breached their fiduciary duty to the client by not getting this agreement in writing. The buyer is not required to know about the statute of frauds. The licensee is. Before discussing some of the many forms a real estate licensee will use in the course of their business, let's review some information regarding Utah law and the real estate purchase contract. 1. When a licensee accepts trust funds, they have 3 banking days to deposit these funds in the broker's trust account unless the parties have a different agreement according to state law. Our current state-approved REPC creates that different agreement and allows 4 calendar days for the licensee to deposit earnest money funds into the broker's trust account after receiving them. 2. A licensee should never sign for receipt of earnest money funds in the REPC until they actually have the funds. The portion of the REPC where a licensee signs for receiving the earnest money acts as a receipt, so the licensee should never sign for receipt of the earnest money until the buyer has actually handed them the money. At the point the licensee has received the earnest money, they should immediately sign the REPC's earnest money receipt and give the buyer a copy of that contract now that the licensee's signature is on it. 3. Never make changes to a REPC or any other real estate document, even if both parties are willing to initial those changes. Administrative rules require a licensee to make any changes to a contract using the state-approved addendum. Whiting out or crossing out anything on the REPC is expressly forbidden. For those who have had their license for a while, this is a change in administrative rule, so be sure to note this change and conduct yourself accordingly. If you have been whiting out or crossing out and having the parties initial the changes, you must stop doing so and use a state-approved addendum to make any changes to the contract. 4. According to the REPC, if the buyer's offer was made subject to the buyer's acquiring a loan and they cannot ultimately get a loan, the buyer does not have to purchase the home since they probably wouldn't have the financial means to do so without the loan. If the buyer provides the seller a loan denial prior to the financing and appraisal deadline, the buyer can receive their earnest money back, and the seller has already agreed to give the buyer's earnest money back to the buyer when they signed the REPC. If the buyer does not provide the loan denial deadline until after the financing and appraisal deadline, the buyer has already agreed to give up their earnest money to the seller, and the seller has already agreed to accept the buyer's earnest money as liquidated damages according to the terms of the REPC. 5. Agency disclosure in the REPC is actually confirmation of agency disclosure. Written disclosure of agency must have occurred prior to the commencement of negotiations, which would definitely mean sometime prior to the signing of the REPC. Agency disclosure prior to the commencement of negotiations is a state law. A licensee must have other agency documentation signed by their client prior to the REPC. 6. A licensee must be very mindful of the dates and deadlines contained in the REPC. These deadlines must be met, or the terms of the REPC will be breached and the offer could be voidable by the other party. If a client were to leave town or otherwise be unavailable at the time when they should be performing some act according to the contract, this could cause the contract to be breached, so it's extremely important to help your client understand the need to perform each requirement of the contract within the timeframes set forth and agreed upon in the REPC. In the case of the buyer's breach, the buyer must lose their earnest money. In the case of the seller's breach, they have already agreed to give the buyer back the earnest money and then pay the buyer the same amount.